Thanks to everyone who's here. I'm sure other people will be joining us. We're really heartened by all of your interest in this important subject. So we're now going to begin the webinar. Good evening, and welcome to the Equal Means Equal webinar on the role of the Equal Rights Amendment in abortion rights. For those of you who are unfamiliar with our organization and the work we do, thank you for attending tonight. We are very happy to see so many new faces and voices joining in the struggle. Before we begin to discuss the subject at hand, why are pro-choice lawyers undermining women's rights in abortion lawsuits, I'd like to give you a quick overview. Equal Means Equal began in 2009 as the ERA Education Project and is entering our 15th year fighting for full equality for women, girls, and LGBTQ people under federal law. Our sole mission has been to educate and advocate for the ERA, which provides equality for all Americans on the basis of sex under the U.S. Constitution. In 2012, we began executing what is now called the three-state strategy. This strategy involved seeking the final ratification of 3 more states to ERA instead of beginning the entire process over again, which is known as the start-over strategy. We at Equal Means Equal believed that the arbitrary deadline placed on the Equal Rights Amendment, which theoretically expired in 1980, was unconstitutional based on the fact that it was placed in the preamble of the amendment and was not voted on by the states, and therefore unfairly advantaged the federal government. We believe that the equal balance of power between the states and the federal government in the amendatory process was clearly delineated in the Constitution, and allowing the government to decide which amendments would receive more time and which would receive less was therefore in clear violation of that balance of power directive. When the ERA was abandoned in 1980, there were 35 states ratified to the amendment. 38 were required to make the amendment law. Article 5, which is the only place where the Constitution addresses amendments, is extremely clear that the will of the people must be enacted upon ratification of 3/4 of the states. Nowhere in the Constitution does it allow for deadlines to be placed on proposed amendments. The Constitution simply says, upon ratification of 3/4 of the states, an amendment shall be adopted. In fact, the 27th Amendment, which was ratified in 1994, took 203 years to achieve ratification. The ERA, on the other hand, was only given a total of 10 years to achieve the 38 state ratifications it needed to become law. From 2012 to 2016, we worked to produce the documentary film Equal Means Equal, which we then used to educate, organize, and mobilize women in the 15 unratified states to once again pick up the fight for the ERA. Equal Means Equal and our allies across the country were able to successfully ratify the 3 remaining states within 4 years of our re-education campaign, with Nevada ratifying in 2017, Illinois in 2018, and Virginia in 2020. On January 27th of 2020, the ERA became the 28th Amendment to the U.S. Constitution. On January 27th of 2022, the amendment became fully enforceable. The U.S. archivist, whose job it is to count and record states that have ratified an amendment, has no discretionary power in the matter, and historically has never intervened to deny publication to an amendment until the ERA. In this case, after receiving a letter from the Office of Legal Counsel from then President Trump's Attorney General Bill Barr, the archivist David Ferriero was ordered not to publish the amendment, and he complied, claiming that he needed a court order before he would agree to publish. This was despite the fact that he had recorded the ratifications of the last 3 states. Equal Means Equals impact litigator Wendy Murphy, who you will hear from tonight, filed suit on our behalf to compel the archivist to publish, and we fought for several years in the federal courts through both the Trump and later the Biden administrations. Surprisingly, despite their purported support for ERA, the Biden administration refused to drop the case and let the archivist publish the ERA. Instead, they continued to fight the matter in court, using the same tactics and arguments as the Trump administration to deny women equality in the Constitution. However, the American Constitution Society, along with many members of Congress and a majority of the states themselves, agree with us that the ERA is valid and enforceable. You can learn much more about this from reading the supporting materials, articles, and videos on our website, equalmeansequal.org, and we urge you to do so. But we are here tonight to discuss how the ERA can stop the rollback of women's bodily autonomy and how it should be used in the myriad of abortion cases making their way through the state courts. When the Dobbs case was before the court, many of us, both officially and unofficially, including lawyer Arlene Rocky, who wrote the amicus brief representing 86 amici in the Equal Means Equal lawsuit against the archivist, urged the lawyers representing Whole Women's Health to use the ratified ERA to prevent the Supreme Court from rolling back a woman's right to control her own body and seek an abortion. For whatever reason, our pleas were ignored by these supposedly pro-choice lawyers, and we lost a fundamental right that women had enjoyed for 50 years, an unprecedented and deeply concerning rollback. Not only were these lawyers aware that the ERA provided the textual basis Supreme Court Justice Alito claimed was missing in the Constitution, but the head lawyer, Julie Reichelman, was appointed to a federal judgeship by President Biden just 3 weeks after losing the case. You can see the full timeline of the fight to compel these lawyers to use the tool of ERA in the case on our website, and we urge you to examine the evidence. Now we are witnessing the continued failure to use ERA, both federal ERA and state ERAs, to protect women in state cases where their rights to choose are being taken from them. Why is this happening, and what can be done about it? To discuss this matter, I would like to introduce our esteemed panel. I will give just a short introduction to each panelist, but I urge you to read their full biographies. Triana Arnold James is the president of Georgia Now and a longtime ERA advocate. Her on-the-ground knowledge of the state of play for women in the South is crucial in our strategy moving forward, since it is in these states that many of the human rights attacks taking place are most virulent and women are at greatest risk. Dr. Eileen Murphy has been working in obstetrics and gynecology for a long and storied career, while also advocating for equality for women and LGBTQ people, most recently as the co-chair of the ERA Publication Task Force. And Wendy Murphy is Equal Means Equal's legal counsel, impact litigator, and a professor of law at New England Law, Boston, the first law school to accept and train women starting in 1908. She is a fierce advocate for equality and is determined to see the ERA adopted and enforced in the states. I'd like to start with a quick introduction from our 3 panelists, starting with Triana.
Unmute. Good evening, everyone. Thank you so much, Kamala, for inviting and allowing this space for us to talk about these two things that go hand in hand. And really, it's just one, because we need the Equal Rights Amendment. We need not only equality, but equity as well. Oftentimes, especially women of color, we're still being paid, 63 cents less than what our counterparts are being paid. And our other Black and brown women are being paid even less. So it's not just needing this, it's necessary. And, in thinking about this panel, I really didn't understand why it hasn't been done. And as I often say, I'm a new generation suffragist. My great grandmother advocated for the 19th Amendment, giving us the right to vote. And we are still, 100 years later, still advocating for similar things. And that is the only right that we have in the Constitution. But the Equal Rights Amendment will give us that right and also protect reproductive health as well. So I look forward to this wonderful discussion tonight. And thank you so much for having me. I also am a board member for the National Organization for Women, which represents about 12 states, 14 chapters across the southern states. And as you know, and as already annotated, that a lot of these bans and heinous laws are across the southern states. And we need to make sure, we need to eliminate that. We need to eliminate all of these attacks on our body, because I truly believe that women should have complete autonomy over their own body and what happens in their home. Thank you so much.
Thank you very much, Triana. I'd like to introduce now Eileen Murphy.
I echo your comments, Triana. My name is Eileen Murphy. I'm an OB-GYN here in Chicago. And I would just like to say that women cannot direct and control their lives if they cannot direct and control fertility and reproduction. We are not unchecked reproductive vessels nor vassals. Childbirth and child raising merits active constraints for women and men alike. So who is having abortions in America? I have good news to share with you on this front. If in 1990 there was 1,429,000 abortions, that has decreased by 56%, such that the most recent statistics are 625,000 in 2021. Similarly, teen pregnancy rates have dropped dramatically, 75% since 1991 and 84% since 1957. Who exactly is having an abortion? Well, 57% of abortions are done with women in their 20s, 9% 19 years of age and less. During that time, 50% of women used contraception during their cycle. 49% of women accessing abortion live below the poverty line, and 59% are already a mother and have a child. Overall, 23.7%, a quarter of women in America will have an abortion by the age of 45. It is imperative that we maintain bodily autonomy. The fact that now we have 14 states banning abortion outright, 2, 6 weeks or less, and then 6 other states with restrictions starting at 12, 12, 15, 15, and 22 weeks. Law and legislators do not belong in the medical examination room. This is one of the most profound, intensely personal decisions that a woman could ever make in her life. There is no room for lawmakers making that decision for you or others.
Thank you so much, Eileen. And now I'd like to introduce attorney Wendy Murphy.
Thank you, Kamala, and thanks everybody for being here. You know, we could talk for a really long time about so many aspects of this issue, but I would like to focus as the attorney here and someone who tries to be as creative as possible to get things done. I'd like to focus on the specifics of, number one, helping everybody understand not so much what the ERA says, but why does it matter that equality be constitutional as opposed to passing a statutory law? I think it's so important that we all understand the heavier your weight in law, am I back?
Yes, but if you could increase your volume a bit, that would be helpful as well.
Okay, is that better?
Yes, but speak up.
So I'm just going to talk very briefly about some overview issues and try to focus our attention on really understanding what's going on in all these abortion lawsuits around the country. Why is it important? Why is equality such an important lens through which we think about abortion rights? Too often, the debate, the conversation centers around how to balance the interests of the fetus and the state versus the interests of women. The more we constitutionalize the status of women in the conversation, the more obvious it becomes in law that it's offensive to encroach upon those rights. So the heavier we make the woman's rights, not interests, but rights, and believe me, rights are different than interests, the better chance we have of winning. So how do we constitutionalize and not just bemoan the fact that Roe was overturned, but really stand firm on the best arguments we can, and in a sense, shame all the courts, the state courts that are now considering these cases, into doing the right thing. So there are two important issues that I want to focus on in terms of what can be very complicated legal questions. One is, what does the ERA offer to abortion rights? And how does that differ from the 14th Amendment? For those of you who know nothing about the law, the 14th Amendment was adopted in 1868, and it said that all persons shall have equal protection of the laws. You would think that would be good for women because women are persons, but actually the Supreme Court for many years refused to recognize women as persons under the Equal Protection Clause. We literally had no personhood until 1971. And when we got personhood in 1971, the court said, fine, women can be persons under the Equal Protection Clause, but we're going to enforce their equal protection rights differently and worse in the courts compared to everybody else. And that's where we remain today. We have unequal equal rights. Figure that one out. What does the ERA do for us? It changes that entirely by basically overturning the Supreme Court and saying you can't give women, half the population, unequal equal protection rights. It's, first of all, it's inconsistent, and it's also just rude to subjugate half the population. And when you don't have equal protection rights, all laws can be enforced unequally against you. All laws against slavery, free speech, child custody laws, and of course, abortion laws. So we are in this pickle because women are second-class citizens right now, which is a bare step up from where we started, which was as non-persons altogether. The ERA gives us that full equal citizenship. The second thing the ERA does, and very few people are talking about this, so we need to, it gives us the ability to argue that even if a law is not discriminatory on its face. In other words, it doesn't say that, women can't vote, but men can, or women can do something, but men can, which is historically what we struggled with. Laws that were explicit about women can't, men can. Those problems are generally resolved today. Most laws aren't explicitly discriminatory in that manner. But what we see are seemingly non-sex-based discriminatory laws hurting women in their impact, and that's abortion. So abortion doesn't say only women can have restrictions on their abortion rights, even though, despite trans arguments about the definition of a woman, even though only certain people can have abortions, the reality is women's lives, as Dr. Murphy said, women's lives are very much negatively impacted if they cannot control their reproductive destiny. So that's what's called a disparate impact or a discriminatory impact. Well, guess what? Without the ERA, you cannot go to court and complain about the impact. All you can complain about is what the law says. Does it say women are treated differently? Now, it so happens that abortion rights are a little bit more complicated because of this historic argument that it can't be discrimination if only women can get pregnant, because men are not similarly situated. They can't get pregnant. Well, aside from the fact that that's a dumb basis for saying that something isn't discriminatory, and much of the law has changed consistent with what I just said, that it's dumb to say a law can't be discriminatory simply because men are not similarly situated. Many courts have rejected that silly argument. But what matters the most is that we are poised today to say, not only does the ERA give us full, equal protection rights, which we should already have, but we don't, as well as the ability to complain in the courts when, despite what the law says, the law has a disparate and harmful impact on women as a class of people. And that is the best argument we can make about abortion, but it's not being made in any of the lawsuits that are currently filed in states across this country. The lawyers claiming to care about reproductive rights, claiming to care about my rights, claiming to represent the interests of me as a woman. They are committing legal malpractice by not arguing disparate impact, and they're not arguing it because they're not making claims under the ERA. And that's why we're here tonight, to talk about how to fix that, how to get lawyers to make better claims, because we lost in the federal court. We lost in the Supreme Court of the United States. Abortion is gone as a right. And if we're going to get it back, we're going to get it back in the states, but only if we make arguments that are rooted in fundamental rights about equality and impact on women's lives. So that's really what I wanted to start with my introduction.
Thank you, Wendy. Thank you for that. I had a couple of questions already that you might want to address because they pertain to what you were just speaking about. One is, what was the 1971 case you referred to, which gave unequal equal rights to women?
Yeah, very good question. It's called Reed versus Reed, which is what, and it's a hard case to criticize when you think about it, because it did give women personhood. So it was a very celebrated case, right? It was the first time the court said, okay, fine, women can be persons under the Equal Protection Clause. But baked into the decision was this horrendous ruling that we're going to enforce women's equal protection rights unequally in the courts. So it was, yes, it was better than zero personhood, but it was also explicit second-class citizenship. So were we celebrating? Sort of. Should we have been? Hell no. And that case, because it was 1971, came up from the Supreme Court right while we were fighting like hell for the ERA in Congress, which passed Congress only a year later. But here's the problem. because the Supreme Court gave us personhood, albeit second-class personhood, it took some of the wind out of the sails in our fight for the ERA, and that decision, Reed versus Reed, is why the Congress had the political ability to stick that 7-year deadline on. The ERA had no deadline from when it was first filed in 1923 up to and including 1971. No deadline, no deadline, no deadline. Why? Everyone knew it couldn't pass if it had a deadline. Well, and we were screaming and yelling, we needed the ERA because we were not persons under the 14th Amendment. By giving us personhood, Congress now had the political ability to get away with sticking that deadline in because we didn't have as strong an argument for the ERA because we were now persons. It's a dastardly thing the court did in 1971, although it was also okay that they created this personhood status for us. It's an important historical thing to remember. The Supreme Court will often give with one hand and take with the other. It makes it much harder to complain.
This next question I'd like to ask Triana to jump in on, as well as Wendy. I'm going to add Triana here to the mix. The question is, it starts with a comment. In my view, southern states and border states are the most virulent about abortion because they want more white babies. I believe that racism and white supremacy are the dominant impetus to the anti-abortion movement, with the facade of ethical or religious concerns. Why have we, media, liberals, and progressives, not highlighted this or developed a public campaign to deflect and defeat the right-wing extremists?
Wow, great question. Elected officials are afraid of that argument. Candidates are afraid of that argument. Because even when after the Charlottesville and they were yelling all of those crazy things about being replaced, some older white men feel that the white race is being abolished and they have to protect the white race. And so with banning abortions, they feel like they're protecting the white race. But my argument is this: if you care about what's in the room, you should care about what's outside the room. When you tell a woman that she got to carry her rapist baby, okay, you're not looking at the fact that that rapist has rights. You're not looking at the fact of the trauma that this woman has to go through for the rest of her life, really. Because you don't stop being a parent at 18 just because, your child turned 18. You don't stop being a parent. But you're not looking at those things. The mental health, you're not looking at that. You're not looking at the repercussions of the economic part of it. Okay. We have made that argument, and that it's not about an abolishment of one race over the other. It's about you staying in your lane. I remember when the abortion ban, the 6-week abortion ban was introduced in the state of Georgia. And the representative that introduced, he was standing at the well. And he went on to talk about the difference between a 28-day cycle and a 21-day cycle. And so when he came off the well, he came out the chambers, and I asked him, I said, well, when was the last time you had a period? Is there any chance that you might be pregnant? When was your last cycle? I said, because those are questions that I get when I visit my OBGYN. And you as a man, I'm wondering, since you could tell us the difference between the 21-day cycle and the 28-day cycle, can you answer those questions? And his answer was, that's not the point. The point is, you don't have a right, or you don't even have a space to even talk about that, because those are things that doesn't apply to you. And of course, you know, he told the Capitol Police I was harassing him, and they almost arrested me. But you know, I was willing to be arrested. But you're fragile. But that also goes to your fragile ego, because here it is. You know, I'm asking you a question, and you could answer it, and the only thing that you could say is that's not the point. But the point is, you don't have a point. You cannot make that argument. You cannot make that position where you could tell me as a woman who has raised 12 kids, the difference between the 21-day cycle and the 28-day cycle. I was also talking to another candidate, and she said, I asked her, was she pro-choice or pro-life, or do you believe that you could be both? And she said, you know, because of her Christian background, she believed in that a man should not be taking life. And so I asked her, well, do you believe in the death penalty? And she says she does. So which one is it? It's either you believe in it or you don't. And it's so hypocritical, especially when they bring in the Christian faith. Because as my son has said, you know, everybody wants to be Christian until it's time to be Christian. You want to use your Christianity as a weapon to assert your point of view on my rights.
Thank you, Triana. I wondered if Eileen wanted to jump in on this from the perspective of an abortion, of a gynecologist, in terms of whether you see some of the things Triana was mentioning. You're muted.
It's interesting that you just mentioned Christianity, and Christianity is fairly recent in human history. Abortion has been around as long as humans have had pregnancies, and because reproduction is such a ongoing phenomenon, many pregnancies through history have been unintended and undesired. So you can look at the Egyptian Ebers papyrus in 1550 BC. They used finely grounded acacia fruit, colocynth, a plant, and dates in 1 pint of honey, mixed, moistened into a cloth, and inserted in the vagina. Ancient Greeks relied upon an herb called silphium, and they imported it from an area in Libya. It was used to such a degree it was driven extinct. Thereafter, there have been all kinds of herbal abortifacients, crazy physical measures like strenuous labor, even battery was employed to hurt women, thinking that that would induce an abortion. But also fasting, bloodletting, pouring hot water onto the abdomen, lying on heated coconut shells, and even sitting over a pot of steamed onions in the 8th century in India. So there's always been a need and a drive to avail abortion services. Here in the United States, just want to tell our audience, 93.5% of all abortions are done less than 13 weeks. 5.7% of them are done between 14 to 20 weeks, and less than 1% or 0.9% are done after 21 weeks. And now 53% of abortions are done medically with the abortion pill that we're trying to protect, the Mifeprex added to the misoprostol. And over 53% of abortions are done medically in the United States. I just want to say that it is crazy that in the 14 states where there are abortion bans, they are OB-GYNs and nurse midwives, family practitioners who take care of women during pregnancy, they are engaging in what would be considered active medical malpractice, being forced to neglect their patients when they encounter complications during the pre-viable period. Just FYI, babies cannot survive before 22, 23 weeks because there's just not lungs. And so, unfortunately, what can happen is the bag of water can rupture. We call that pre-viable, preterm, premature rupture of membranes, or there can be placentation issues with bleeding and hemorrhaging. So in these states, providers are forced to sit on women until they are so sick, hemorrhaging, or with blood poisoning. And that is the definition of insanity.
Isn't it true that before abortion was criminalized, men could force their wives to be aborted against their will in the United States?
I can't comment on that. I think I ran into some laws that the women would be prosecuted if they had an abortion without their husband's consent. I've seen that, but I can't comment on the question you just asked.
I believe it's true that men could abort their wives before women had, many rights. If a man didn't want his pregnant wife to come to term, he would have her terminate the pregnancy, whether she wanted to or not. Wendy,
Well,
do you know?
but here's why that happened, and I'm sure it happened all the time, and it didn't even have to be in writing. You didn't need a law to say a husband can force his wife to get an abortion, because under the doctrine of coverture, which is the vestiges of such are still with us, a woman's legal existence is completely subsumed within that of her husband throughout the marriage, which means she doesn't exist. She can't go to court. She can't complain. She can't call the police. She doesn't exist. So of course he can make her have an abortion. He can do whatever he wants to her. She doesn't exist. She wasn't a person for most purposes until 1971. I have to keep reminding us of that, which, by the way, let me go backwards a little bit on the question about politics. Both parties love abortion as a device by which they can control women. Let's be clear. This is not like only the Republicans are the bad guys. Nobody historically has advocated for abortion without restrictions, even though countries around the world where there are no restrictions have the lowest rates of abortion. So if the true goal here was to limit abortions, we'd follow those countries where, because they respect women's right to choose at all times of the pregnancy. And by the way, they don't choose because they're frivolous about it. They don't choose abortion at 9 months. And recognizing that in the countries with fewer restrictions, they have fewer abortions. So that data alone is all you need to understand that abortion isn't really about the unborn at all. It's not about any of the crap people debate. It's only about men controlling women's lives. It's like rape. Abortion allows men to control women's destiny, which enables the patriarchy to continue, and it maintains women's second-class citizenship in a very, kind of easy to do way, because we can prop up religion and feelings about the unborn as the justification for controlling women's lives, which feels less awful, which feels less onerous, which feels less dictatorial and anti-democratic. But the reality is we also have laws against rape, right, that don't actually prohibit rape, because they require, to prove rape, you have to show non-consent, penetration, and force. You have to have force. Well, that tells you right there that rape is not actually prohibited, because 90% of rapes don't involve the use of force. But if women did have autonomy over their bodies, and that's what we're talking about with abortion, is this fundamental right to autonomous authority over the self. If women had that, rape wouldn't require proof of force in addition to non-consent, because non-consent is a proxy for no autonomy, right? The same thing is happening with abortion. We don't want women to have autonomy, so we regulate abortion. And then sadly, abortion has also been used as a distraction to take our attention away from equality, which would solve all these problems. And that's why we always have to keep coming back to equality, because we can spend our lives debating on balance, the unborn versus the woman, the unborn versus the woman. Was enough force used, was not enough force used, and you're spinning your wheels and you're never talking about autonomy. Autonomy is such a fundamental human right, and it's a 100% zero-sum game thing. Like, you have 100% autonomy or you got nothing. You got slavery, right? So Justice Louis Brandeis, a very long time ago, famously said, autonomy is over the self is such an important human right. We didn't even put it in the Constitution, lest the courts do things to chip away at it. It's so basic, we didn't want to put it in writing. And women, because we weren't persons until 1971, never had autonomy, and we're clawing back from that hellhole every time we try to do anything to assert authority over our own destinies. Abortion is just one of the ways that our destinies are being denied us. Rape is another. I could keep going. But
let's move here to the Wendy, can you explain please why we are intervening in Texas, what the Texas case is about, and why we decided to do that intervention?
Yes, Texas is probably the most important case that people are paying attention to right now, because it got all the public attention in terms of the cases that eventually led to the Dobbs decision, the overturning of Roe. And so a lot is going on in Texas as well, because there's a kind of rabid political willingness to really restrict abortion in the most aggressive way possible. So they were right out of the box with the 6-week abortion ban, as were many other states, but Texas was particularly aggressive about doing it. So their 6-week ban was a little bit changed after it was as strict as it was. They added a few things. So the 6-week abortion ban, which is true for most states, says there can be no abortion after a heartbeat, which is roughly 6 weeks. But they also have built into it, of course, that there's an exception for the life of the mother, which they can't not have. Constitutionally, no state can totally ban abortion, because you have to at least allow abortion to save the woman's life. That's true in every state, and that will never change. It's when health becomes a factor that abortion becomes more questionable in terms of what states are doing. And in Texas, they actually moved the needle a little bit and said that abortion will be allowed even after 6 weeks to protect not only the woman's life, but her health if serious bodily injury might follow. So it has to be something extreme. It can't be emotional distress, and it can't be, let's say, an illness that's extremely painful and disturbing to the body, but not likely to kill her. So there's still a huge restriction there. But here's why we intervened. So there's a lawsuit trying to, the lawsuit that was filed last spring in Texas was filed by the Center for Reproductive Rights on behalf of some OB-GYNs and some women who had difficulty getting abortions because of the difficulty of figuring out. The doctors had concerns about whether they would get in trouble and go to jail if they give the abortion because they weren't sure they met the standard. So the lawsuit was filed to enjoin enforcement of that ban. And it very quickly went to what's called a preliminary injunction stage, which is to say the lawyers said, we don't just want to win this lawsuit, we want you to put the brakes on now. That's what a preliminary injunction is. You file a lawsuit and then you instantly ask for the court to stop it because you don't want this to continue at all. In that sense, it's an unusual lawsuit. Not all lawsuits have these requests for injunctions, but this one did. And the trial level court again, this is in the state court, not the federal court, the trial level state court judge said, I'm granting the injunction. This violates the Texas Constitution. Now, here's what's important about this case. The plaintiffs, again, well-known group, the Center for Reproductive Rights, filed their lawsuit under the Texas Constitution, and they cited several provisions, including the Texas equivalent of the ERA. Okay, Texas has a state ERA. It's had it for a long time. Under the Texas ERA, the Texas Supreme Court ruled, again, many years ago, that when there is a claim made about sex discrimination, the court has to use strict scrutiny. So remember when I said earlier that the United States Supreme Court in 1971 said, fine, women can have equal protection rights, but we're not going to enforce them equally. We're going to bump them down. That was the difference between strict scrutiny and lesser scrutiny. What women have now is called intermediate scrutiny. That just means that when the court is reviewing the problem, in this case, the abortion restriction, they're very rigorous if they use strict scrutiny. They almost never let anything go through under strict scrutiny because they're just very demanding. They don't want anything discriminatory to make it through strict scrutiny. But intermediate scrutiny is very loosey-goose. Lots of stuff gets through intermediate scrutiny. And under federal law, the Constitution, we only have crappy second-class intermediate scrutiny, which is why we're fighting for the ERA. It gives us that top-tier strict scrutiny, maximum legal protection under all laws at all times. And that's what the ERA gets us under federal law. Well, under Texas ERA law, they already have strict scrutiny. They not only have an ERA, it's protected by strict scrutiny, which is not true in most states. In about half the states that have state ERAs, they use something less than strict scrutiny. Texas uses strict scrutiny. I very excitedly read the case that was filed, because I knew it was being filed under the Texas ERA. And I said, I can't wait to see how they're arguing strict scrutiny under this abortion restriction. It's going to be great. We're going to use this as a model all over the country. This is going to be great. Well, you'll never believe what I saw. I read their case and they asked for less than strict scrutiny. In fact, the phrase strict scrutiny was nowhere in their case. Nowhere. So I decided to intervene on behalf of Equal Means Equal and the Elizabeth Cady Stanton Trust and the group that I represent, the Women's and Children's Advocacy Project at my law school, New England Law Boston. I said, we're going to intervene if for no other reason than to shame these people into explaining, why wouldn't you ask for strict scrutiny? The court already ruled in what's called the McLean case that women get strict scrutiny under the state ERA in Texas. I called them, I emailed them. Why are you not citing the McLean case, which gives you strict scrutiny? Why the hell are you asking the court to review these abortion restrictions under that second-class intermediate scrutiny standard? That's going to give the court the wiggle room they need to uphold the restrictions. Why would you do that? Silence, dead silence. So when we intervened at the Texas Supreme Court level, which is where the case is now. And what we said was, it is unacceptable. It is legal malpractice for this court, for any lawyer, legal malpractice for any lawyer to ask for second-class treatment, especially when the Supreme Court of Texas has already ruled that we're entitled to that top-tier treatment. And I wanted to make sure, and this is exactly how I worded the brief. I said to the Texas Supreme Court, you are about to decide not just about abortion restrictions, but what the Texas Constitution means for women in Texas. Are they entitled to strict scrutiny? Or are you going to bump it down to that crappy second-class status simply because the people who filed the lawsuit asked you to apply that crappy second-class standard? I will not let it happen. I filed this law. I filed to intervene in order to demand of the Texas Supreme Court that they at least consider applying strict scrutiny and allow us to intervene so we could make the argument that women in Texas are entitled to maximum legal protection for all their rights, not just abortion rights, everything. And why would any lawyer go into court, I don't care who you're representing, and ask for second-class treatment? Who does that?
That brings us to a very interesting question. We saw how the lawyers in Whole Woman's Health versus Jackson failed to apply ERA, failed to ask for strict scrutiny. We're seeing it in Texas. We're seeing it, I believe, in Nevada. What do you think is going on with these lawyers that are supposedly pro-choice, pro-woman, in many cases, pro-Democrat, and are still literally throwing women under the bus? Do you feel that this is some kind of a conspiracy? Do you feel that it's ignorance? Do you feel that it is just self-serving? What is the reason for this?
Obviously, I can't answer that directly, but I can tell you what I think about a couple of aspects of it. First, I should say about Nevada, the plaintiffs there, because Nevada has restrictions that are in the form of funding support for abortion. They're not a 6-week ban, but they're funding restrictions there. And the lawsuit that's now pending in Nevada is seeking to overturn those funding restrictions. They did ask for strict scrutiny under their brand new state ERA, which is great. But the factors that are required under strict scrutiny, they did not ask for all of them, which is another cagey little way to get women into second-class status. Again, strict scrutiny is a buzz phrase in the law, but what it means is really important. There are certain criteria you have to ask for under strict scrutiny. You can't just say, I want strict scrutiny, because that's you're not a good lawyer if you just say that, because strict scrutiny requires the court to ask certain factors, ask certain questions, and apply certain factors to determine whether, in fact, they can uphold the restriction as constitutional. And the Nevada plaintiffs, again, another reproductive rights group, they did not ask for all the factors under strict scrutiny to be applied. So it's a kind of a less terrible thing than what Texas did, but it's still terrible. And we are intervening there as well pretty soon. And I want people to know that. As for why, let me just say this, because people don't know this. There are a lot of seemingly pro-women's rights groups in this country that aren't actually pro-women's rights. They are either proxies for the Democratic Party, or worse, they're anti-feminists masquerading as feminists. And it's really hard sometimes for the public to know what the real deal is. Who's funding them? What do they actually care about? What are they doing? And are they doing it right? It takes a lot of knowledge to read a lawsuit in Texas that's constitutional, which is triply complicated, and understand that what they were doing was dangerous for women. Very few people have the capacity to do that. So we all sit back, read the news, and cheer for these groups that are doing lawsuits. Yay, they're trying to help our abortion rights. Then you read it and think, oh my God, these people are not helping us at all. You got to read the stuff and you got to educate yourself. And that's why we're doing this webinar, to help people be critical consumers of information and not march like lemmings down the street just because the newspaper said such and such a pro-choice group has filed a lawsuit. Hip, hip, hooray. Not good enough. So I do think that, number one, being a proxy for the Democratic Party is a kind of tried and true tradition in terms of undermining women's rights while appearing to be supportive of women's rights. I'll cite the National Organization for Women as an example. When they were founded in 1966, Alice Paul and the Women's Party, they were on a rocket ship trajectory to get that ERA through, and Alice had been fighting for it forever, and she was doing such great work. The ERA was virtually, passed by the time 66 came around. And up pops the National Organization for Women. And at their first national conference, they announced that they would be opposing the ERA. Why would they do that? Why would a group come up out of nowhere, declare itself a women's group, national women's group, and announced that they're opposed to women's equality. Now they
I thought NOW was formed with one of the four sort of reasons they were formed was to see the ERA completed.
No, they were opposed to it at their first national convention. Their membership shamed them into supporting it. So they did ultimately testify, lukewarm as it was, in support of it in 1972. When the hearings were done, they did offer a little bit of positive testimony, but they were shamed into it by their membership. Their initial policy was, we're going to oppose the Equal Rights Amendment. My sense is they wanted it to be broader. They thought sex alone wasn't a broad enough category, which is fine, but then don't declare yourself a women's rights organization. And I could say the same thing about the feminist majority and Ellie Smeal. They really have done nothing to help with the ERA. They've been a hindrance, but they keep sending fundraising letters out saying, you know, send us money, we support the ERA. And Ellie herself has said, you know, well, we don't really do anything for the ERA, but we use it as a fundraiser because it raises a lot of money. I can't explain why Ellie would do that. I mean, I've seen her be duplicitous. I was on a panel with her. She said she was going to support the ERA and file all sorts of lawsuits. Then she did nothing. I don't know how much she raised by saying that, but she didn't do it. When I
Well,
said
she told me directly that she told me and my vice president, Natalie White, that we should not, that we were ordered not to go after the 3-state strategy. And we disobeyed that. And then after we went ahead and did it, then they came around to support it. But sort of. They weren't on the ground like we were. And then they did send out those massive fundraising letters after every state ratification.
And refused to support us with an amicus brief when we filed suit in Massachusetts, even though we were the only lawsuit on behalf of women. They refused to support us. I mean, this is all important. So it's also important to remember that Ruth Bader Ginsburg came out viciously against the ERA a month after we filed. And she also spoke to the archivist.
It was shocking. It was so shocking when that happened. I couldn't believe it.
Ruth Bader Ginsburg. So you think about Ruth Bader Ginsburg saying some things publicly, but doing terrible things behind the scenes. Same for NOW, same for feminist majority. Why do women's groups do this? My answer is because they're being funded to undermine the ERA, because both parties don't want women to have equality. There's an enormous amount of money being made from women's inequality. They're constantly pitting us against each other, Black women against white women, you know, trans against white. I'm just sick. I'm sick of it. I think it's time for us as women, regardless of what else we are, we could be Jewish, Black, Muslim, we could be any kind of woman, but we need to come together and talk about what suffering is when you are female. We might suffer for all sorts of other reasons, but when we talk about the femaleness of our suffering, we need to stick to it, because that's how we work together without getting watered down, which is exactly what the moneyed interests want us to do. They want us to feel watered down because we're suffering in so many ways. No, Alice Paul said it best. We are women first. We will fight for women's equality and only women's equality. And once we have our voices in place as fully equal persons under the law, everything else we care about will get better because our voices will be louder. That's Alice Paul. That's why Alice Paul had to be marginalized. It's why the Women's Party had to be destroyed. She was too smart.
I'm going to go ahead and move into some questions because we do have a bunch of questions that are backing up here. So the first question in the order they were received. Many women, including myself at one time, thought that women already have equal rights. Why can't we do a national public service campaign explaining that? So I'll just start by saying I was one of those women as well in 2008. I thought that we were equal. I drank the Kool-Aid. I was told that I was, you know, not just equal, but superior, girl power, all of that. And I found out that no, we are not equal in the Constitution. The problem is that over 80% of Americans believe that we are equal in the Constitution. And I agree with the questioner that we need a national public service campaign explaining it. But since the US government makes $1.7 trillion a year in underpaying women and paying women unequally, there really is no impetus, there's no funding for such a campaign, because it goes against what the majority of the corporate environment wants, which is to continue to be able to underpay and exploit women. Does anybody else have a point of view on the fact that most Americans believe women are already equal?
It's absolutely true that they
Oh,
do. And I want to say one quick thing. The way to get around the corporate ownership of news, because none of us owns a network or a newspaper, the way to get around the problem of how to get the word out, aside from social media, which is also hard to get the word out these days, we should all be getting on school boards, local school boards, easy to get on. Get on a local school board and demand that they start teaching this stuff in school. I got 5 kids, not one of them learned anything about women's inequality, the ERA, nothing. I went to law school. I didn't learn about the ERA or women's inequality. It's just intentionally not being taught. So we need to inject ourselves into the teaching process, which means getting on local school boards and changing the damn curriculum.
It's very challenging to do a PSA in our fractured media environment. The logistics of reaching the audience, we need to have a focus group on that, ladies. And I would just like to second Wendy, the National ERA Publication Task Force, equal means equal, will be getting their letter. They signed on as one of 84 organizations. And just yesterday, we sent a letter to President Biden with 84 organizations strong, demanding immediate publication of the Equal Rights Amendment. We also got the support of the American Constitution Society, and we're really excited about that. Along the way, as we are trying to get organizations, as you described, Wendy, it was a reality check as to those who did not pony up. So we will keep on keeping on, and there you go.
Did you find that women's organizations were not willing to sign that letter?
Certain larger entities that you would think would be self-evident. Yes.
Did they give any reasons for why they were not doing so?
Yes, and we'll talk about that offline.
Triana, do you want to comment on that?
Well, I just wanted to say, as a part of the National Organization for Women, we have always supported the ERA. It's a part of our 6 core issues. And constitutional equality is paramount. And so, from my understanding and history that I've known about, and I'm so proud to be a part of now, is Shirley Chisholm, Flo Kennedy, all supported from the very beginning. And I remember reading about the National Organization for Women when they were at CDOC in 1966 on how it came, in the late 60s, early 70s, when it all came to be. So I can't say that, and I'm not speaking for all of now, but from my understanding and my history in education, now has always supported the Equal Rights Amendment. I personally have always, like I said, my great-grandmother was a suffragist, and I call myself a new generation suffragist. I am a new generation suffragist and will continue to advocate for the Equal Rights Amendment. And I strongly believe that if we have the Equal Rights Amendment, then all of these laws, just bringing it back, especially across the southern states, would not exist. All of these heinous laws, all of these abortion bans, all of these book bans, even in our healthcare, would not exist in having the Equal Rights Amendment. So as far as creating a national campaign, I think it starts with us. I think it starts with those that are willing, especially Black women. But let me also say that Black feminists did not feel a part of the struggle. And still some of us feel like we're not part of this. So that's where you get the divide between Black women and white women, and Black feminists and white feminists, is because that Black women feel like, and I'm not speaking again for all Black women, but feel like, hey, you know, we need you so we can show that we're diverse. But then, you know, don't speak up, don't say this, don't say that, get back in the back, stay on the back burner until we need you. So that's where the divide comes in. It's not that it's just out there. It's just that it starts with us. It starts with where we are true to what we're saying. If we are true to making the ERA happen, then we got to stop this us versus them and come together. Whether they supported it in 1966 or the 70s, 80s, all of that doesn't matter. It's 2023. It's time for us to come together so that we can get this done, because one group cannot get it done by themselves.
No,
Right on.
Hey, Triana, I think the new mantra is all is all. We need to have equality for all. No fragmentation. No more.
Right.
Yeah, and Triana, the other thing is, one of the problems with large groups, and this is true of now, it's not true of all the chapters, and I don't know that it's true even of the people at now, but what's true of now as an organization is they have their fingers in too many issues. And I'm not saying this because they shouldn't do that. If that's their business, that's their business. But Alice Paul's genius, because she believed equality was the only thing worth fighting for because it affects everything else. You have to only fight for one thing, one issue, equality. Once you get that done, you can afford to spread your wings. There is no women's group that, except for Equal Means Equal, that only focuses on equality for all. And that's where we become, you know, that place where together happens, because we don't want to hear about anything else. We don't want to talk about immigration. We don't want to talk about taxes. We don't want to talk about healthcare. We want to talk about equality, because equality fixes everything. And Alice Paul's single-minded focus was so damn effective. She got shit done. And that's kind of what I'm getting at is, if you're a women's group and you have 6 things that you care about, and they're not all about equality, you have just watered down and weakened our power. And I won't.
Wendy, can I just, however, Triana, is that National Organization of Women signed on to our letter yesterday after this huge campaign in multiple state chapters. So they are upstanders on this drive, calling for publication of the Equal Rights Amendment without delay. And we're so proud of the National Organization of Women, unlike some other organizations in so many other chapters. They are upstanders.
Let me just jump in here because we have had multiple questions from the audience regarding this issue. They would like to see the names of all the organizations who signed on to the letter. Where can they find that? And they want names, please. Did Women's March sign? Did Planned Parenthood sign? Did Rise Up for Abortion Rights sign? Did the Feminist Majority sign? People are asking these questions, and I think it's important not to withhold information. I'm not saying you're forced to answer it now, but you should make available the list of organizations that signed on so people know.
We're proud to share that imminently. And then this campaign is going congressional, and it will descend or engage individuals as well. So you will know very, very soon. Some of those names, I can tell you, did not sign on.
I figured. I just want to get to a couple more of these questions here. One was for states such as California that have state constitutional amendments making abortion a legal right. How does the ERA add to the autonomy women have over their bodies?
Well, it's a really good question. It's a kind of complicated answer. So here's the thing. If you have a state constitutional right to abortion, but your state constitutional ERA doesn't give strict scrutiny, you don't actually have much of a constitutional right to abortion. This is why I keep saying equality is everything. You can change laws all day long, pass a law giving people equal this and equal that, and women have equal pay and equal. If they are subject to unequal enforcement because the Constitution denies you strict scrutiny, then your laws are worthless, no matter what they say, even if they say women shall have a constitutional right to abortion, because when you go to court to enforce it, the courts have the freedom, the ability to impose limitations by judicial fiat. They are allowed to enforce it unequally. It's like pushing crumbs on a broken plate. Those kinds of laws, every kind of law, falls through the cracks if you don't have strict scrutiny in your constitutional ERA. You have to fix the plate first before you put any laws on it. Otherwise, what the hell are you wasting your money on? So it's kind of the problem with half the states that keep passing these laws about abortion rights, and everybody's so happy and the women go and support them. I don't even want Roe to be codified in any state, because it's still going to be subject to unequal enforcement. And Roe, by the way, we may as well get it on the table, Roe never gave women full autonomy anyway, right? It was always this trimester thing, and women got to consult with their doctors, and then once it's viability, you got to, blah, blah, blah.
What about the Hyde Amendment and making poor women, disadvantaging poor and minority women immediately?
Yes. There's no question that after Roe, we got even more restrictions. And let's be clear, let's really tie the knot between abortion and ERA for a minute. When abortion rights were first created by the Supreme Court in 1973, they were considered a fundamental right, which is subject to strict scrutiny. Remember, we keep talking about this. There's nothing more important than strict scrutiny. When it comes to enforcement of rights in the courts, strict scrutiny is the best. Well, Roe versus Wade, because the court said abortion was a fundamental right, it came with strict scrutiny. And that meant very few restrictions could make it through. Very few restrictions were tolerated. Even parental notification laws were not constitutional under strict scrutiny. 1992 comes along, and the court bumps down abortion from a fundamental right down to some kind of an interest, a liberty interest, way weaker than a fundamental right. And then all of a sudden, strict scrutiny is gone, and undue burden is imposed as the standard. And out of nowhere come all the new restrictions, parental notification laws, waiting laws, and all these things. Really important to remember why strict scrutiny matters, because it's the most protective legal standard you can stick to any law. And unless you have it, it doesn't matter. It doesn't matter if the legislature passes a law codifying Roe or the legislature constitutionalizes abortion. If you don't have equal protection of those laws, you've just wasted your time, money, and resources.
Another question that was on the table is, I believe that Illinois has the ERA in its state constitution. You spoke of strict scrutiny. Does the Illinois ERA provide strict scrutiny?
I do have the list of which states have it, but you're going to have to give me a minute to find it. So ask another question and I'll be back at you. I have to go look it up.
Okay. Another,
I
oh, go ahead, Eileen.
know that we've had our equal rights
Uh-oh, you're breaking up.
since
breaking up.
1970.
Sorry, go ahead. I think you froze.
Let me fix.
Oh, there you go. Okay, what did you say?
Illinois has had an equal rights amendment in its constitution since 1970. And in fact, Illinois, whether or not we have strict scrutiny in our state, is very, very, very supportive of reproductive rights in Illinois. And in fact, we have become a key access state, and there has been the greatest number of abortions performed in our state compared to other states. Seen an increase in abortions coming to Illinois, and per month it's gone up by about 2,100 abortions per month in Illinois as we help out women in Wisconsin and Missouri and Indiana and elsewhere. So we are stepping up, and so functionally Illinoisans are protecting abortion in real time without question.
I do have the answer. You want that?
Sure.
Okay, so Illinois does have strict scrutiny, as does, I'll give them off, they're very short list here. California, Connecticut, Florida, Hawaii, Maryland, Massachusetts, New Hampshire, Oregon. Pennsylvania has what's called an absolutist standard. Texas, as I mentioned, has strict scrutiny, and Washington also has an absolutist standard. The rest of the states that have ERAs use something less, and then there are about 12 states with no state ERAs at all.
I think
Georgia is one of them.
yeah.
But we're working on that.
Georgia is one. That's exactly right.
Right. But we're working on it. We are working on it.
I know you're going to get it done, Triana.
Be prepared come session 2024. Be prepared.
So we have very little time left. I'm going to give one more question, and then I'm going to go to closing comments. And in the closing comments, I think we should talk about what we think we need to do moving forward. But a question that was asked was regarding how in Iceland, all the women went on strike for one day to push for equal pay and an end to gender violence. Could that ever happen in the United States for even a day? Women do most of the work. We could gain a lot of clout from striking and showing how desperately everyone needs our contributions. I agree, and I think we should mobilize and hold a strike. Absolutely. You know, and I think that would be a very powerful thing to do.
I wish,
Yeah.
I'm sorry.
No,
I wish, oh my gosh, I wish that we would do that. I mean, even if we start out with, you know, somebody put out an email today about boycotting Hobby Lobby, but what about Walmart? I mean, you know, I really wish, you know, and I think about the history of the Montgomery bus boycott, which started with 5 people. And look at what it did. It turned into desegregation. So if we can get those 5, you know, I don't know. Like I said, we all need to come together and, you know, and do something like that. I really wish that we would go, you know, I don't know, some kind of hunger strike or a boycott. But it has to be somebody major. It can't be, I mean, I don't really shop at Hobby Lobby. So I was like, okay, I can boycott Hobby Lobby. But I'm every other day, I'm at Walmart. And I mean, I wouldn't have a problem with, you know, and we're the biggest consumers. We're 52% of the population. We're the biggest consumers. You know, we do all the work in the home and outside the home. Why is it that we can't do that? So anybody put that out there, I'm down.
You know,
I'm down for it.
Equal Means Equal's Director of Communications, Alice Crenshaw, she has an organization called Strike for America, and this is one of their main tenets, one of the main things they're trying to do. And I think we should really consider mobilizing, even if we start now and plan it for a year from now, we can slowly build to doing that. So I'm going to, just in case this webinar cuts us off at exactly 6:30, which is 5 minutes away, I would just like each one of us to make our closing statements. We'll start with Triana.
Great. Thank you so much, Kamala. Thank you, Wendy and Arlie. Thank you all so much for this great conversation. And, just like I said, what was the numbers? 90 million women live in countries that ban abortions. If we can get those 90 million, women and more and come together, we could take our rights in our back. We can take those rights. And if we can just come together on one accord, all organizations, all women, Black, white, Hispanic, I'm not with the whole party thing, and come together, we can make sure that these heinous laws, especially these abortion bans, does not exist. We can nullify that, we can get rid of it, we can eliminate, and we can gain our rights. Not only are we talking about equality, but we're also talking about equity, and we can do that, but we got to do it together. Thank you.
Thank you. Eileen, closing comments?
Well, despite the state bans, legal abortions haven't fallen nationwide in the year after Dobbs. And there's an organization under the Society of Family Planning that's called We Count. And they are maintaining month-to-month statistics on what has happened to abortion utilization in America. And the crazy thing, despite what is going on and how they're trying to shut us down, guess what? Abortion went up by 0.2% last year, and there were 115,000 less abortions in the abortion banned states, but the other states stepped up so that there were 117,000 abortions done, a net increase. And this is testimony to women and others coming together to get things done. Other states are taking care of, the states that still have abortion are taking care of women in states that don't. And they have stepped up mightily with all kinds of telehealth and online this and that and hotlines for miscarriage and abortion. And then another recent report is from the Institute of Labor Economics. They looked at birth statistics for the first 6 months in the 14 banned states. And they calculate that 20 to 25% of the women who had unintended pregnancies ended up giving birth. And that amounted to 32,000 additional births that would not have been predicted. So there is forced birthing going on in America now for women. So, but I believe in women. We got to come together in this fractured media environment, and between Equal Means Equal and Shattering Glass and the National ERA Publication Task Force, of which we're all aligned. Please find your voice, join us. We are doing the work for equality and to get the Equal Rights Amendment published.
Thanks, Eileen. Wendy, would you like to make
I'll try to speak in 60 seconds in case we go dark. It is absolutely a leadership problem. There is no leadership in this country as far as the fight for equality goes. And I don't mean, of course, excluding us and the groups that Eileen just listed, but in terms of meaningful, heavily funded leadership, it's intentional that there's no leadership for the purpose of bringing women together like Black Lives Matter. There's just there's no incentive in the moneyed interest to get women to come together as women. Even the Women's March had nothing to do with women. It was the dumbest march ever, because people went there trying to talk about equality, and they talked about everything but. And that was probably the most depressing misuse of 1 million people. I mean, it was awful. So we need leadership. We need to be single issue focused. Equality is the only issue. We don't want to talk about anything else, just equality or plus equity. I'll give Triana equity too. We need to develop our own media, because mainstream media will never support our efforts. We need to always use our own language in a way that is revolutionary in style, which is to say, every time a single sexual assault or domestic abuse case happens to a woman, we need to say that is an injury not only to her, but to all of us as a class and to the community as a whole, because that's what happens when someone is targeted for violence because of who they are, because they're female. That language helps to create the feeling that that everybody has skin in the game, right? That you don't have to be a woman to care about the subjugation of half
Right.
the population. So skin in the game matters. And, I also feel very strongly about fighting in the states for strict scrutiny in all the state ERA situations, because we have a lot of work to do there, and we have a lot of room to grow there. I got it wrong before. There are 19 states with no state ERAs at all, and half the remaining states that do have state ERAs don't have strict scrutiny. If we just fight for strict scrutiny in the states, we can win the equivalent of the ERA without ever winning the ERA. Because if every state has a state ERA with strict scrutiny, we get the benefit of the federal ERA without ever having to get the federal constitution to step it up. So I think those things are worth doing, but they all require bodies, because we're never going to have money. No one's ever going to give us the money to do this, but you can substitute dollars for bodies. And the more bodies we get, the better we are. Alice Paul knew it. She was brilliant. She brought people together, whether they had a dime to their name or millions of dollars. She saw the commonality of all the women that worked for the cause. And we need to go back to Alice Paul's strategy, because she was right. She was absolutely right. She created the Women's Party because neither party was good for women. And that remains the case today.
Thank you, Wendy. I'd like to thank everybody very much for being here with us tonight. I'd like to urge you to please go to equalmeansequal.org and join us and become a member. I also want to say that I agree with what everybody said, but I do believe that we have a window of opportunity to push through the publication of the Equal Rights Amendment. We have done the work. 38 states have ratified this amendment. We believe the amendment is fully valid and enforceable. We only need a 5-minute phone call from President Biden directing the archivist to publish. And I think we should not lose sight of that, even as we continue to work on all these wonderful suggestions in the states regarding scrutiny, et cetera, et cetera. So please visit our website at equalmeansequal.org to join us, learn more about what we do, and support our work. And thanks again for coming, and have a great night.